Good afternoon, everyone. My name is Jessie, and on behalf of the Centre for Gender and Law at Durham and the Centre for Criminal Law and Criminal Justice, I'm really delighted to welcome you all today to the launch of Dr. Emma Milne's new monograph called Criminal Justice Responses to Maternal Filicide, Judging the Failed Mother. So we have 4 speakers this afternoon. Emma's going to kick us off. She's going to speak about her book, and then we have 3 discussants, which we're delighted to have with us. I'll introduce each of them more fully before they speak, but just to let you know the running order, after Emma's spoken, we'll then have Professor Loraine Gelsthorpe, Professor Sally Sheldon, and then Professor Michelle Oberman. So without further ado, so that we can get on to the really important stuff, I'll hand over to Dr. Emma Milne. Thank you, Emma.
Thank you very much, Jessie, and thank you everybody for attending, and particularly to the 3 speakers. As you'll have seen from Twitter and emails, this has been actually quite difficult to organise, surprisingly difficult, between strike action and then me getting sick. So thank you for persevering with us and registering every time. It's much appreciated. It's really excited to be talking about this book. So it actually came out in August, so it's kind of been out for a while now. I don't know how long academic books continue to be new for, but we'll pretend it's still new, at least for tonight. So what I'm going to try and do is just have a think about the kind of key issues and key things that I think the book adds and makes it important and makes it worth reading, hopefully. And then probably not talk for too long and then hand back to other people, and hopefully they agree it's important and a contribution. So just some background for the book here. As you can see, it was the funders are at the top there, so just some thanks to those funders for allowing the book to go ahead by providing the contributions they did. It's come out of my PhD study. So my PhD, I looked at 7 cases from England and Wales between 2010 and 2015. They were heard in Crown Courts in England and Wales. And these were cases where women were suspected of causing the death of their newborn children. And they were convicted of certain crimes in relation to that. And then with some extra funding from the SLSA, after I'd completed my PhD, I then added a number of cases, bringing the study up to 2019 and a total of 15 cases in total. And the book very much came from a place of appreciating that there's a lot of literature around the world about why women kill their children and what happens to them and the reason why they end up in this situation. But there's much less written about what the criminal justice system does with them afterwards. From a legal point of view, there's quite a bit written in England and Wales on the Infanticide Act and what the Infanticide Act is and what the Infanticide Act does. But again, far less written in terms of how that Infanticide Act is then applied, and particularly even less written on what is done with these women through the criminal justice system if it's deemed the Infanticide Act can't be applied or shouldn't be applied. So that's very much where the book came from, was the acknowledgement and realization of that gap, and trying to fill it by looking at these particular cases. So, as I've said, it's 15 court transcripts over a period of 10 years. All of the women were convicted of criminal offences that were relating to the death of their fetus, so their late-term fetus or their newborn baby around the time of birth. And that around the time of birth becomes quite important, as I'll demonstrate when I talk about the law in a moment. So the cases were analysed for 2 reasons. Firstly, to see how the women were discussed. So what was said about these women, how were their actions considered, and their backgrounds just talked about. And then secondly, to look at the law and how the law was talked about and how it was understood and how it was being applied. So just for those who perhaps aren't as aware of how the law is structured here in England and Wales, there's effectively this line of birth that becomes incredibly important for understanding the criminal law. So if there is evidence that you have been born alive, and born alive is defined in some bizarre legal ways around your entire body being out of the birth canal, then the fact that you are born alive means that you become a full legal person under criminal law, which means that crimes such as homicide, child cruelty, crimes against the person, all of these crimes can be applied to you as a legal subject. If, however, there's no evidence of live birth, or you die, a fetus dies before it's born, then in England and Wales, those other offences, the homicide offences, the child cruelty offences, they can't be applied. Now, that's not the same in lots of other countries, particularly in the United States, where fetal homicide laws have been put in place, and in some states, fetuses are considered to be legal subjects in ways that they're not in England and Wales. But here we don't have that position in place. So we do have a number of other pieces of legislation, though, and offences that can be used in instances where there isn't evidence of live birth. And these offences, so procuring a miscarriage, child destruction, and the concealment of birth, became very much the focus of the book and the key aspects of it. So procuring a miscarriage is an 1861 Offences Against the Person Act, section 58 offence. It is the ending of a pregnancy at any point in that pregnancy. So effectively, the procuring of a miscarriage, the ending of a pregnancy, is illegal in this country at any point. The Abortion Act of 1967 provides a defence to that in England and Wales, but obviously that wouldn't be applicable for the sorts of cases that I've been looking at. Child destruction came about in 1920. I never know if it's 28 or 29. I always get it confused. It's one of those. End of the 1920s. And it is under the Infant Life Preservation Act, and it criminalises the killing of a child who's capable of being born alive. So effectively, we're talking about a viable fetus being killed with the intent to do so. And then concealment of birth is a real anomaly out of these, I would say, and it is it criminalises the hiding of the dead body of a baby in order to hide the fact it's ever been born. Again, this is a piece of legislation that came out of 1861. And as I talk about in the book, all three of these pieces of legislation have an incredibly long history. They've developed out of a long period of time of mistrusting women and mistrusting what happens if they get pregnant when they shouldn't be pregnant, and a baby dies in unusual or uncertain situations, or she tries to end her pregnancy herself before the baby's born. But one of the key things, as I'm going to go on to talk about just now, is that these offences, they've kind of sit on the statutory books, and particularly Sally Sheldon's talked a lot about abortion and procuring a miscarriage and how that continues to sit there. And what my study has really demonstrated is whilst they're just sitting there, they're also then unfortunately being used in ways that they were never intended to be used, and I would argue are actually being misused to criminalise women when potentially they shouldn't be criminalised and couldn't be criminalised for anything else. So another key aspect around these cases, and this is an area in the literature that there's an interesting divide, I would say. So the divide between scholars who see these women who end up in a situation where they're killing a newborn child or causing the death of a newborn child as very much responsible for their actions. You know, they should have done something. That what I would consider to be quite harsh judgments of these situations, seeing them as quite callous and self-serving women. And then there's a whole other section of the literature that would suggest otherwise, that actually these are quite vulnerable women who end up in these situations because of abuse and poverty and quite desperate situations. You can probably work out which side of that debate I fall onto. But the conclusion that I've come to when looking at the 15 cases that I analyse is that all of these women experience a crisis pregnancy. So a pregnancy that for one reason or another causes them a crisis. And they are incredibly vulnerable on the whole. I always tend to say that you don't end up in a situation where you think the best thing for you to do is to just not tell anybody you're pregnant and hope it goes away, unless you are in a bad situation. Like it's just not a normal thing to do. The normal thing to do is to go to your doctor and be like, I've got a problem, we need to deal with this, and actually dealing with it. So these women are incredibly vulnerable just in and of the reasons why they end up in the situation they do. They also, there's an added complication, is a lot of the time they actually have very little knowledge of the pregnancy, or if they do have knowledge of the pregnancy, it kind of goes in and out of focus. So they might be aware at certain points and then they repress it. And there's evidence in some cases that they've actually got no idea that they were pregnant at all. And all of the cases end, either the woman takes steps to end the pregnancy herself prior to going into natural labour, or she goes into natural labour. Often in that situation, the labour and delivery is a complete shock to the woman. She's actually not expecting to, and she ends up giving birth to the child on her own, and the baby dies at some point in that period, so either whilst in the process of birth or shortly after birth, either from her violent action or due to neglect often. So one of the key things I do, and this very much came out of the data, so looking at the court transcripts and seeing the sorts of things that were being talked about, one of the key things that became very clear was there was this sense in the transcripts that all of these women should have been responsible mothers. And the responsible mother, from the analysis of the literature that I use, is effectively pulling on the idea of the myths of motherhood, which has come from feminist theorization around how motherhood is perceived and understood, and women are expected to behave as mothers. And then also a more recent literature which talks about how pregnant women are effectively required to be responsible in order to protect the well-being of their fetus. And you bring them together, you effectively have the idea a good mother is going to be a responsible pregnant woman. So if the idea being she's going to do everything she can to put her fetus first, regardless of her own wishes and intent and desires, it's the fetus that is the most important. And if she doesn't do those things, then she's clearly the bad mother and the irresponsible pregnant woman. And this is very much tied up with ideas of risk. So there's no such thing as a no-risk pregnancy these days. Every pregnancy is risky. It's just that some are more risky than others. And pregnant women act as both protectors of a fetus, whilst also potentially causing the fetus risk if they're not going to do what they should to make sure that the fetus is in the best position possible and the best protected, and other suggestions of things that pregnant women should do. Interestingly, those ideas also kind of now exist before women get pregnant. So the World Health Organization is still contemplating whether or not it should produce guidance that says that any woman of reproductive age shouldn't drink alcohol just in case she gets pregnant, because that would then arguably be a risk to the fetus. Probably don't get me started on that one, but I'm happy to have a rant about it in questions afterwards because it just makes me livid. But we can see these risk narratives taking place. So perhaps unsurprisingly, the vast majority of the women in the study that I look at are very much constructed as the bad mother, but also the irresponsible pregnant woman. And the things that very much come out when there's a discussion of what's happening in these cases and how the woman has behaved is this idea that she's failed to put her fetus first and she's failed to manage that fetus's risk. And both of these things come together to very much make the woman a bad mother. So for example, and I think this is probably one of my favorite cases out of all of them. So this is from the case of Sally, who was convicted of the concealment of birth. So she hid the dead body of her baby after it had been born, stillborn. So as the judge said, your chaotic lifestyle choices, including alcohol abuse and promiscuity at the time of your pregnancies, was such as to put the good health of any unborn child at risk. Now, I just think one of the key aspects around this remark in sentencing, and that really comes out in pretty much all of the transcripts, this idea that actually her key failure here has been how she behaved while she was pregnant, which in many respects should have been completely irrelevant when we're thinking about the offence that she was convicted of. So she was convicted of concealment of birth, which is an offence of hiding a dead body, effectively. That's what the crime is meant to do. That's what the statute says. But as we can see, this offence is effectively being, or what is being expressed in the court is that actually a big part of her failings is how she behaved while she was pregnant. So this very much has led to the conclusion that I've drawn in the book that actually a key aspect here is that prosecutors have this menu of criminal offences that they can draw on and they can use depending upon the situation and the circumstances within these cases. So if they can prove live birth, and they obviously have the offences that are available for any person once they've been born alive. But if they can't prove live birth, they have these other offences that they can effectively use as what I deem proxies for fetal homicide laws. So in exactly the same way as we can see concealment of birth being the offence here, the actual focus is much more upon her failure as a pregnant woman and her failure to manage the risk she posed to her fetus. So this really, for me, opens up questions, and these are questions that I really want to go on to think about and develop following the book. This is kind of post-book work now, is thinking about this idea of risk and the purpose and the way in which risk is framed. So it's always framed as from woman to fetus or newborn baby, both in the court cases, but also just in wider discourse around the idea of pregnant women and the risk that they pose. Very, very, very rarely, if at all, is the risk ever seen to flow from fetus to woman. So even in cases, you think if a woman has cancer and she's pregnant and the doctors are saying, listen, the fetus won't survive if you need chemotherapy, even in that instance, they're not really posing and suggesting that the fetus itself is the risk to the pregnant woman. They're suggesting that the cancer is the risk and the fetus is, you know, an unfortunate victim of the fact that if she's going to have the chemotherapy, she's probably not going to be able to continue the pregnancy. So fetuses are really not seen as capable of being risky for women, which I suppose in some respects makes sense because it's, you know, it's a cluster of cells inside her body. So this isn't what I'm really kind of trying to push here is not an idea of it's an individual fetus that could be a risk, but actually it's when we think about the ways in which women are meant to mother and be pregnant within society that potentially might mean we want to think about this flow of risk in a different way. One of the consequences of the idea of the risk being from woman to fetus is that it very much individualizes that woman and individualizes what she does. So she alone is going to be risky. It's not going to be the wider circumstances. It's not going to be the structures of society that put her in that position and therefore mean she is risky. It is her and her alone who has caused that risk and who has failed to take responsibility for us. And of course, the not huge actually amount of work that's been done on the idea of gender and risk very much points out that we can't think about risk without thinking about gender. So particularly Chan and Rigakos, their work on this was, I think, you know, particularly enlightening. And they very much pull out in their case of what we think about as risk and like what or who is legitimate risk is very much gendered, but also so is what or who is not legitimate risk is also very much gendered. So in this situation, the notion of being pregnant isn't conceptualized in society as being risky. Instead, what is conceptualized as being risky is pregnant women. Pregnant women are inherently risky towards their fetus, and some women are particularly risky. And we can see, and that's very much reflected not only in my cases, but also in other research that's been done. Certain women are policed much more heavily in terms of the risk that they are deemed to pose to their fetus and to wider society. So one of the questions that I ask in the book is how, or should we be reversing this idea of risk? Because in many respects, pregnancy and motherhood is a huge risk to women. It's a very gendered risk, so it's a risk that is imposed on women, not necessarily because of the inherent experience of pregnancy, but because of the way in which society expects women to be pregnant and expects women to mother. So those myths of motherhood that very much play on women when they're pregnant and women when they're mothers. And we can see this in terms of whether or not pregnancy is seen to be legitimate or illegitimate. Is it right you're pregnant at the time you are? So think about the discourse we see around teenagers when they become pregnant, and you know, the notion of being pregnant as a teenager is just seen to be a really negative thing. Same around abortion. There's such that in our society we understand that there are good abortions and bad abortions. There's abortions that just shouldn't happen, not from the position of the woman. So this isn't about whether or not a woman wants an abortion. This is about whether or not society sanctions her abortion. We can then see the much more physical experiences of women in terms of when they become pregnant, when they become mothers. So the damage that's done to women's careers, the economic hardship, the labor of having a baby. A woman is much more likely to end up doing a substantial amount of childcare compared to her partner, mostly her male partner I'm talking about here. So this is when we think about the risk that pregnancy and motherhood poses to women. Again, I'm very much talking about the structural harms. It's about the ways in which society frames and structures pregnancy and motherhood and expects women to mother within that context. But as I say, that's not recognized. It's not recognized as wider society, and it's certainly not recognized in these cases. In these cases, it is very much an individualization of she is the problem, she is the risk. It is her that we need to focus on when we are thinking about what's going on in the criminal justice system. And this embodies this idea and frames this idea that she will absolutely take care of her fetus, and if she doesn't, then she's simply just failing. So this individualized aspect has a real consequence upon how her conduct is then seen, and the laws that are then drawn upon and applied to her specific situation. So they're not seeing the crisis, they're not seeing the structural causes that have led her to this position where she's giving birth on her own and the baby's dying in one way or another. And there's a desire, there really does seem to be a real push, I would say possibly over the last 10 years, to really try and convict these women of something. So particularly over the last 10 years, we've seen a number of convictions of women who kill newborn children for murder, which is something we just hadn't seen in about 25 years. So there seems to be this kind of punitive turn towards these women, and a complete lack of desire or ability to see that actually this is a product of crisis, and it's a product of the situation that women find themselves in because of how society understands and sees motherhood and pregnancy. And one of the wider aspects, and I think this is something that is probably, again, for future work, is actually the way in which society, the way in which the courts understand the wrongdoing here, and they apply their regulations and they apply their judgments of these women, in many respects has a regulatory aspect for all maternal conduct and all maternal standards. So it creates this normative idea of these women are bad, what they have done is absolutely unacceptable, they are individually to blame, and they are effectively the pin-up girls for how women should not be behaving when they're pregnant and when they're mothers. And I think I will leave that there. Thank you.
Thank you very much, Emma. And I see you're exiting your slideshow. Excellent, lovely. So just quickly to note that there's already a couple of points in the chat, someone picking up on the idea of risk, and also Joanna Foster encouraging you to rant against the proposed WHO guidelines, but maybe we can leave that till the Q&A, which reminds me that I actually forgot to mention the Q&A section of today's seminar in the introduction. So at the end, there'll be plenty of time for discussion. So if you have a question for Emma or for any of the panelists, do feel free either to put it in the Q&A or the chat box, or if you have particularly nice things to say about Emma's book or presentation, then raise your hand and I'll allow you to speak and you can say them in person. But I'll hand over now to Professor Loraine Gelsthorpe, who is the Director and Professor of Criminology and Criminal Justice at the Institute of Criminology at the University of Cambridge and a Fellow of Pembroke College. Loraine has wide interests in the links between criminal justice and social justice in respect of race, gender and social exclusion, women in sentencing, and more generally just in the field of women crime and criminal justice, and is an expert in this area and are very well placed to comment on Emma's book. So I'll hand over to you, Loraine. Thank you.
Okay, thank you very much. Well, it's a huge honour to be invited to help launch this very impressive and important book. I think producing a book of this quality is not only a labour of love, but it also involves emotional labour, delving into the poignant and powerful stories of women who've killed their own newborn children. So I'm full of admiration for Emma for raising the profile of this very thorny issue. It's a hugely challenging book, but in a good sense. It's a book which provokes, prompts, points, politicizes and persuades. It turns things upside down by suggesting perhaps that it's not surprising that some women do kill their own newborn children, given the fact that society creates a situation whereby pregnancy is often experienced as a crisis, as you've just described, to the extent where women feel they can't accept and respond to their pregnancies. So I think Emma asks searching questions about what societal influences there are which drive women to take steps to illegally end their pregnancy, or indeed not take steps to seek help when they realise that they're about to give birth. It's reminiscent in some ways of Erin Pitz's work, about domestic abuse and Scream Quietly, thinking about the question of why women, people always ask the question, why don't women just leave domestic relationships? But in fact, the real question is, what are the barriers for women in leaving abusive partners? So in many ways, I think the book is yet another twist on the familiar discourse of victim blaming. And Emma points out that we need to consider the hardships of motherhood. I'm using the word hardships. I think at some point in the book, Emma refers to the harms of motherhood, but the language of harms and hardship is something we might want to discuss. So there is indication that we need to consider the hardships of motherhood, the controls and regulations regarding women's sexuality and motherhood, the substantial burden of pregnancy placed on women. And I think that the book very rightly turns critical attention to the role of criminal law and criminal justice in sanctioning women when they take what many people perceive to be extreme steps to remedy the hardships and challenges of pregnancy and motherhood. I'm prompted to think about fight, flight, or freeze too, and I think there's something about the denial which suggests that women are sometimes frozen and cannot do the things that society expects them to do. So ostensibly, the book is about 15 particular cases of women suspected of causing the death of their newborn children and convicted of criminal offences relating to this. But it's so much more too. Women are controlled and free themselves from control in many different ways. As Carol and Barry Smart put it so well in their 1978 book, Women's Sexuality and Social Control, the social control of women assumes many forms. It may be internal or external, implicit or explicit, private or public, ideological or repressive. It may not even be perceived or experienced as social control. But what's clear is that the notion of a normal woman, normal motherhood, is insidious. The image of a normal woman, motherhood, is built into the formation and implementation of law and social policy, however, and in day-to-day relations between individuals. But this image doesn't necessarily accord with actual behaviour, and it does not merely delineate what is usual or conventionally appropriate female behaviour, but also defines what is morally expected. Only recently, I was on an interview panel for something non-academic when a colleague interviewer concluded that someone wasn't suitable for the course she was applying for because she hadn't had her children yet. Such strong assumptions. Most of us around the table did gasp, and the woman who'd asked the question quickly realised that she had made a wrong assumption. Nevertheless, such a powerful discourse of expectation. Woe betide the woman who chooses not to have children. Woe betide the woman who can't have children. Woe betide the women for whom it simply doesn't happen, let alone woe betide the women who kill their newborn children. So the context for this detailed and rich empirical study of maternal filicide of newborn children is thus one of presumed female normality. In the courtroom, as Emma has described, the mother who commits maternal filicide is seen as a failed or failing mother, or as irresponsible. And through this book, we learn that the mother is seen as illegitimate. In other words, she's an unmotherly monster and therefore has to be criminalized. Well, I simply want to conclude by saying that I think this is a hugely important piece of scholarship. which details the challenges in very compelling fashion. The book concludes with the claim that to acknowledge the legitimacy of these women in disposing of an unauthorized pregnancy is politically, culturally, and economically skewed to limit the rights and freedoms of all women. Well, I think there are messages in this for all of us, but I would very much like to think that, Emma, that you will be invited, or that you will invite yourself to talk to judges through the Judicial Training College and to members of the Sentencing Council, because I think that is where this ought to be a must read, but for many others too. So thank you.
Thank you very much, Loraine. A wonderful commentary on the book there. So at this point, we'll turn to Professor Sally Sheldon, who is Professor of Law at Kent Law School, University of Kent, and her research interests are primarily in healthcare law and ethics, legal regulation of gender. And she's published widely in the area of medical ethics and law, including a book on abortion law. So is again an expert in the area and very well placed to comment on the book. So I'll hand over to you, Sally. Thank you.
Thank you very much, Jessie, and thank you, Emma, for the invitation. I was also very excited to be part of this panel. I think one of the things I reflected on in reading your book was something an old law professor of mine used to say, which was that legal education sharpens the mind by narrowing it. And I think part of what he meant by that was when we're teaching law students, we tend to teach them this key skill, which is ignoring all of the context, ignoring all of the noise, and working out what narrow range of facts it is that are legally relevant to the resolution of the case. And then when they've done that, we teach them that the thing they really, really need to remember about the case is the ratio decidendi, that one legally binding principle, which will then have precedent value in other cases. And everything else going on around the edges of that, the messy reality of litigants' lives, we think is just so much noise. So one of the things I loved about the book, and Loraine has already mentioned that, is you really challenge us to think differently about that, and to look through the other end of the telescope, and to start with the messy reality of people's lives, and then to look back at the legal principles and how well they're reflected in the legal principles. It's a simple shift, it's a very radical shift, it's difficult to do well. And it's so interesting, I think, to read the book and to have that perspective and to think again, having started from that other end. So 4 very brief thoughts that I found striking about the book, or reflections it caused me to have, having inverted the telescope and come at things from a different angle. I mean, the first thing, and this is a really obvious point, but it's a very striking thing for me that comes out of the book, is when you put the lives of those 15 women together and you reconstruct what we can know about their lives. There's such similarities in their stories. There's these factors that are just reoccurring, and it really reminded me, I mean, I shouldn't have been surprised in any way by that, because it reminded me to think back to a really small bit of research that the British Pregnancy Advisory Service did in 2008, where they just pulled together all of the women who sought access to abortion after 22 weeks of gestation in 1 month. So what are the factors that are causing these women to present late for abortion services? Now, we know in one way those women are exceptional. 95% of abortions in this country take place before 12 weeks, less than 1% after 20 weeks. So it's a small minority of women. But the thing that was really interesting to me about their stories and their reasons for seeking abortion is that they look just like every other woman who's seeking access to abortion. So they talked about not being ready to mother now, wanting to be a better mother at a different time in the future, wanting to mother their existing children more effectively. And then there were a specific set of vulnerabilities that did distinguish them, that meant for some reason that they had just fallen through the the cracks. So they were scared to tell their parents. They talked about homelessness, poverty, drug use or self-harm. There was just something going wrong in their lives at that moment that meant these broad structural factors became particularly difficult and particularly pointed for them. And a lot of them, again, also talked about sticking their head in the sand. That was a very common factor in those stories. So I was really struck by your research that when you put those cases together, how similar they look. That's the first observation. And then a second observation, starting from there, how similar these cases look. It's really striking and really shocking how different the penalties faced by those women were. And it's absolutely impossible looking at those cases together the way you present them. It's so powerful. You can't see that as reflecting different levels of culpability, I don't think. You have to see an awful lot of luck involved in those cases. So it's to do with the timing of events, it's to do with the availability of evidence, it's to do with how these women's stories and women's lives fit within this drastically incoherent patchwork of archaic legal principles that have been developed over centuries for different reasons. It's the particular prosecutor that's involved in the case and how zealous he or she is about bringing the action. It's the moral views of the judge, the individual judge who hears the case. So you anonymize these 15 cases, but there's at least one of them is immediately obviously identifiable to anyone who's worked in this area because it's a case that's gone to the Court of Appeal. And we know the judge in that case was a member of the Lawyers Christian Fellowship, an organisation which is devoted to applying God's justice on the ground, who is known to have anti-abortion views, and imposed a sentence that was later overturned by the Court of Appeal as manifestly disproportionate. So we know that there's all of those things going on as well in those cases, and it comes out so beautifully, I think, in your book. So third observation, I'm really interested in the work that you've done in excavating what I'm going to call the biography of these provisions, because Emma, other people probably won't do. That's a term I've been trying to work with in my own work, because I think it pulls together really well this idea of a statutory norm being rooted in a particular set of culturally contingent, historically contingent realities, kind of fossilizing those realities, but then only ever taking effect through interpretation, which is necessarily a contemporary activity. So you get these statutory norms which are in one sense rooted in the past, but they're always being reinterpreted and applying, and you can see these, you bring this out really well, these rich developments where you've got the same statutory language that's been used to different effects, and you beautifully pull out, I think, this development of how we move from punishing lewd women to punishing women who offend against current norms of motherhood. So it's a kind of biography, the life of these provisions that just carries on after they've been created. So final obligation, Loraine wants judges to read your book. I would like parliamentarians to read it, because there's such clear implications here for law reform. I think I would challenge anyone. I mean, I'm sure Loraine said your book was provocative, and I'm sure it will annoy a lot of people, and that's all well and good, isn't it? That's I think that's part of our job as academics. But I would challenge anyone to come away from this book wanting to defend this incoherent patchwork of legal principles that we have in this area at the moment. So even the 15 cases that you've been able to find and to get the transcripts for, 15 cases is enough to demonstrate how starkly inconsistent these rules are in their application. And you might hope that the Law Commission would think that this was an appropriate area to look into. So Law Commission charged with codifying law, eliminating anomalies, repealing obsolete and unnecessary enactments, reducing the number of separate statutes. The Law Commission actually, as some people in this meeting will know, in 2015 decided it was going to look into the offences against the Person Act, which is the statute that contains the abortion offence and the concealment of birth offence that Emma talked about. And they wanted to look into that because they thought it was anachronistic, that the language was anachronistic, it contained overlapping offences, there was inconsistency in sentencing. So all of the stuff that Emma's wonderful book teaches us is wrong with this particular area of law that she's describing. But the Law Commission decided that it couldn't look at these offences, abortion, concealment of birth, because they are political. They raise political issues that are outside its remit. So the Law Commission won't look at it. Government doesn't want to look at it because these are divisive issues inside political parties as well as between them that generate nasty letters. Private members' legislation is really unlikely to be able to resolve any of these problems unless the government gives time to help that kind of legislation get through. So it's an incredibly hard nut to try and crack, even though you've shown so clearly what's wrong with this area of law, which isn't, of course, just to conclude, to say that we need to stop trying. And I'm so glad that you've written this book and made these arguments and set out this evidence base, because I think this is what academic work can do in this area. So congratulations to you.
Thank you very much, Sally. Some really thoughtful comments on the work there. So I'll hand over now to Professor Michelle Oberman, who is the Catherine and George Alexander Professor of Law at Santa Clara University. She's internationally recognised for her scholarship on the legal and ethical issues surrounding adolescence, pregnancy and motherhood, and has written numerous law review articles exploring the legal system's limitations when endeavouring to respond to issues such as abortion, rape and infanticide. So not to sound like a broken record, but is again an expert in this area and incredibly well placed to comment on Emma's book. So I'll hand over to you now, Michelle.
Thanks so much. I was really thrilled to be asked to participate, even before I read the book. Just the idea that my work continues to be of any use to researchers in the field is really, like, that's every academic stream. So so thanks. And then when I read it, it was just such a powerful experience of understanding what it means to tell a thicker truth about stories that I thought I knew, and that I think the world needs to know about. And I think the enduring value of your book may well be in how thick a truth you told about these cases, your careful attention to detail, your awareness, your astute awareness of bias, whether your own or any of the folks interacting with these women, offering multiple lenses through which to understand the patterns and through which to debunk a perception of pattern, really speak to an agility in your mind. And I'm hoping for a long and full career, and I'm looking forward to reading what you do next. So I read it also as a person who's profoundly distracted by the impending loss of the right to legal abortion in my country. And so a lot of what I have to say, I think, will tie back to what I've been working on more recently, which is abortion. But I want to start by noticing that you embraced full throttle patriarchy, and I loved it. Just like, it's time to dust off that word and really talk about the frame that it gives us for understanding what years ago Marilyn Frye wrote about the double bind. And it's an essay that I read when I was just a baby feminist myself, called Oppression, where she talks about one of the hallmarks of patriarchy is that every road is mined. Every road, right? Female sexuality, you can be a slut, you can be a prude. There is no safe way to navigate that path. And I thought about it in reading your book, because the best filicide defense requires explaining the action of killing your child in terms that the patriarchy can understand. A desperate woman, abandoned, her mind imbalanced by those weird bodily functions, right? You have to blame and pathologize the individual for what are ultimately societal or structural ills. You make a point that the scripts that accompany all the moms, good mothers, bad mothers, natural ways of behaving after a baby, after you have a baby, after a baby dies, all of these scripts cover up the varied and complicated truths in your 15 cases and in our lives generally. And yet, as the others have said here, the patterns here are so striking. They're so familiar. One case echoes another, right? So the struggle is what to make of these patterns, which I think provide in themselves evidence of the double bind in these cases, and also what to do with the criminal justice system's response to the cases, again, with that double bind frame. And because I'm a lawyer, I'm just going to be super pragmatic. I don't swim as easily in the world of theory as I'd like to. So I very much wanted to believe that the British Infanticide Act evened things out and lessened the punitive tendencies and the powers of judges. I wanted to believe that, like, the sort of civilized result was going to be probation and counseling, and that it was just my country where you see an incredible range of cases, of resolutions in these cases. Neonaticide, it can be probation, it can also be life, right? The outcome depends on the quality of your defense lawyer and the open-heartedness of your judge, and to a lesser extent, but a very real one, on the media, right? If you can keep the media off the case, you might have a very different outcome, right? And so it was really disheartening to learn that actually the same sorts of arbitrariness affects these cases on the other side of the pond. I understood going into the book that the price of using the 1922 Act was likely to mean enduring paternalistic speechifying by judges, and yet I cringed to read statements like the statement of Elizabeth's judge when invoking lenience, you know, like her pathological denial, the pressures of living. It was just like to reduce to like sort of like hollow sentiments, the fabric of her life that way, and to make that the price for a lenient outcome was really like, I think that was where I just was like, oh, this is the double bind, right? Where the best defense lies not in asserting your client's right to deviate from conventional tropes, nor in showing the court that the tropes are racist or sexist or flawed, but instead showing how your client's life circumstances made that conventional narrative inaccessible. That's your best road to defense, right? Feel badly because she couldn't have this happy mom life that every other good mom has, like, you know, to just make it so we're not actually going to tell any truth at all. So all of that leaves me wondering about assertions of gender discrimination as a legal strategy in cases that involve non-conforming moms. It's most easily named, the gender discrimination, when you gather together numerous cases and then the patterns speak for themselves. You can name the structural discrimination in ways that you can't as an individual lawyer easily defending a single client. It's, you know, the pattern makes the system clear. And I want to actually close by talking about the use of patterns in asserting gender discrimination in a number of cases that I've been sort of in one way or another reporting on out of El Salvador. And I think I want to end there because it's a little bit of good news in an otherwise pretty bleak area of the law. So in El Salvador, abortion is completely legal. There are no exceptions under the law. It's the world's strictest ban, and they're quite enthusiastic about enforcing it. And yet it's very hard to enforce. Medicine is everywhere. 1 in 3 pregnancies ends in a medical abortion. Drugs are purchased very easily on the street with cell phones, and the efforts to enforce their law have led to a really paradoxical pattern that only people like us will recognize, which is that you get these late-term obstetrical emergencies where women come in either not knowing that they were pregnant or having known that they were pregnant, but they didn't get any prenatal care. They're women coming from the margins of society, the very most vulnerable populations. The average sort of educational attainment of this population of women with these emergencies is around a 3rd grade education. They come to the hospital generally having delivered their baby at home, hemorrhaging heavily, and the doctors very quickly suspect that because they are poor and because they've come in alone, they did something on purpose to end that pregnancy. So the question becomes, where's the baby? Where's the baby? Police are often called in right away. She's shackled to the bed. And then as it moves from the hospital as in crime investigation scene to the jail where she's transported, and then into the courtroom, the motive evidence becomes her poverty. She's poor, her marital status, she's single, she couldn't afford a baby. Even her status as a rape victim will be used as evidence against her, right? So the lawyers that I've worked with there involved in defending these cases have done a really terrific job on wrongful convictions. Baby wasn't born alive, you shouldn't be convicting her. They end up being sentenced to murder because the fetus was viable, and so therefore they're able to bind them over from abortion to murder. And so it's just, one case at a time, showing that there's a fatal legal error, and then insisting that the woman be released and be tried, right? The lawyers at the Center on Reproductive Rights, along with these Salvadoran advocates, won this huge victory in December of this past year, December 2021, in the Inter-American Court of Human Rights on one case. Her name was Manuela, and she was just like the cases that I've been describing. 2008, sentenced to 30 years for prison after suffering this pregnancy loss. She later died in prison for the failure to treat and diagnose and treat her lymphoma. But rather than taking this case just to the Salvadoran courts, they took it to the Inter-American Court and asserted a claim that El Salvador was violating her rights to life, health, judicial protections, guarantees by a policy of discrimination and gender violence. And they called into view the structural discrimination against impoverished women, that the state doesn't prosecute rape, that doctor-patient confidentiality is not being protected, that she doesn't have adequate treatment or access to treatment for an obstetric emergency free from any forms of gender violence. And the idea that those arguments could be heard is really thrilling. It's revolutionary. It stands on work like yours. It stands on the fact that there were cases that enabled those lawyers to tell the story of gender discrimination. And so I want to offer that up as just sort of a little bit of a light that we can point ourselves toward in otherwise pretty challenging times. And thanks again for the opportunity to engage with your work. It was really meaningful to me.
Thanks very much, Michelle. And I'm sure Emma is currently trying to quickly work out how she can include El Salvador as a case study for her next work and get free research trips to Central and South America. I'd also like to welcome Dr. Chloe Romanis to the panel. Chloe was teaching earlier on today and has joined us slightly late. She's co-director of the Centre for Gender and Law at Durham and is going to be taking over the Q&A session and chairing responsibilities shortly. We'll just give her a little while to settle in. There are a number of questions and comments in the chat already, which are really wonderful, which I'm sure she'll be ready to read out. Again, if you have any questions, please do put them either in the chat or the Q&A, or if, as I said earlier, you have particularly nice things to say, please feel free to raise your hand and Chloe will press the big blue button that will allow you to talk. But perhaps before we go over to the Q&A, maybe Emma, did you have any comments you'd like to make in response to the discussion that has just been had with our three speakers? Turn to you quickly and then we'll go to the Q&A.
Yeah, I mean, just thank you for saying nice things. Not that I thought you were going to say horrible things, but it is lovely. So thank you very much. And I'm thrilled that you could join us. Like all three of you, your work has just been so influential for me since long before my PhD. So it's an absolute pleasure for you to be here and to be engaging with this work. So I think I'll leave that there.
Okay, so I'll start by reading out some of the questions in the chat. I guess just one thing to say in joining late, sorry, I was at the Advanced Issues in Criminal class, and one of the things that they've been taught this year is this book Emma did early on, and they've engaged with it amazingly, and they've just really loved all of the themes that are really coming out here, both within what I've caught from the speakers, I'm sorry I was late, and also in the book that I've had the privilege of reading. So I'll start with the first question from Professor Susan Edwards. So Emma, I'm going to assume this is directed to you. It says, perhaps you might say something more about the historical shift from the medicalization of infanticide with its disease model in psychosis, which was itself a very uncertain foundation, to a more modern view of the impact of social and environmental factors. Of course, the Infanticide Act could only apply where the mother killed the infant within 12 months of the birth of her newest infant.
Sure, yeah, so the Infanticide Act is a funny one, because it does, on the face of it, when you read it, it does very much look like it is this psychological defense, and very much akin to diminished responsibility, and the balance of her mind was disturbed. But as the work of legal historians and historians have shown, particularly Tony Ward, who, again, I'm thrilled that Tony is here today, have shown actually, when Parliament were enacting it, although they used this very medical language, there was very much this recognition that actually when women were killing their newborn children, it was very much for social reasons. And there was this sense of it being much more of a social madness rather than a psychiatric madness. And there's evidence, so Karen Brennan, who I do quite a lot of work with, she's talked about this in her work as well, that there's evidence that politicians much more saw infanticide as closer to intoxication, that she was temporarily out of her mind because of the situation she was in, rather than seeing it as this kind of psychiatric or like close to insanity type defense. So that's, you know, when it was enacted, that was very much the position, and very much this perception of what the Infanticide Act was doing. Interestingly, I would now say we've gone the other way. So rather than it starting as psychiatric and ending up social, it started as social, I would say, and has ended up psychiatric, because the way that infanticide is now being interpreted through the Court of Appeal, and particularly in the case of Tunstall, which was heard in 2018, very much seeing it as she very much needs to have a psychiatric problem that we can pin this to. And actually the Court of Appeal has effectively made infanticide the same as diminished responsibility. So I think that's the shift that we've seen, and the consequence of that. And well, maybe I can't say it's a consequence, because unfortunately we've got so few cases, and prosecutors in England and Wales are regionalised, so they make these decisions as a regional office rather than as a collective body, although I assume they must have some sort of guidance, but maybe not. When they make these decisions about whether or not to charge for infanticide or to accept a guilty plea of infanticide after a murder charge has been brought, the few cases we do have would suggest that there is much less desire and willingness by the Crown Prosecution Service to accept the to accept an infanticide plea, and instead they seem to really want to push for murder. And so I'm doing some research now where I'm trying to interview members of the Crown Prosecution Service and solicitors and barristers and judges to try and get their take on these cases and on the current law, because, you know, the real question that I want to basically ask somebody is, why are you not using the Infanticide Act anymore? Why have you abandoned this piece of legislation? Because the consequence is there are now 2 women in prison who are serving, I think, about 20 and 17 years each. And there's a third woman who was convicted just before Christmas, who her barrister did a stellar job and managed to get her the minimum sentence, which was 9 years, which is still far too long for a woman in her position, who I would say didn't have the level of culpability that the law would suggest she had to be in prison. But, you know, it's better than 17 or 18 years. So the Infanticide Act is, I think there's more work to be done, or at least I hope there is, because I'm doing more work on it. So hopefully people still think it's important work to be done. But it really does still have this, this interesting dynamic in terms of how it has previously been interpreted and how it's been interpreted now, and the consequence that has for women.
Great, thank you so much. There's another question that's come in as well, asking about the role of forensic psychiatrists. So it's saying that they'd like to know whether forensic psychiatrists were involved, and if so, what their role was, and did they share this discourse that that you've described and the speakers have described on normal and abnormal motherhood.
So most of the cases were guilty pleas, in which case forensic reports were effectively summarized by the prosecution, and usually in line with simply justifying why the prosecution had A, charged with that offence, and B, then accepted the guilty plea. So the discussion of the psychiatric reports were usually much more along the lines of, this psychologist has confirmed that this woman had depression or something like that. It very much usually just kind of goes along those lines. And so I've seen one of the cases where it did go to trial. It was a murder trial, and I've seen the evidence given by the psychiatrist. I haven't seen the report, but I've seen the evidence. The questions very much simply fall on the psychiatrist attempting, if they're for the defense, attempting to prove that yes, this woman did have the psychiatric condition that her barrister is arguing she had, and that psychiatric condition would amount to disturbance of the balance of the mind for infanticide, or a recognized medical condition for diminished responsibility. So they don't in and of themselves, from what I have seen, which is quite limited, I would say, they don't in and of themselves perpetuate the same ideas of motherhood in terms of the evidence that's presented. Instead, I would suggest, although this is very much kind of moving out of my area, there is an attempt, I think, and I think this goes back to the point Michelle was making earlier, of effectively pigeonholing the psychiatric evidence in to kind of fit the defense that is available. And the defenses that are available are these medicalized psychiatric defenses. So I don't think, certainly from what I've seen, there isn't evidence that the forensic psychologists are themselves perpetuating these norms of motherhood, but instead it's the system of the criminal justice system and the way that defenses work that is taking their psychiatric conclusions and foisting them upon women, and effectively saying, clearly she's mad, therefore we shouldn't send her to jail for 20 years.
Thanks. I think that was a really thorough answer. There's another question from Professor Susan Edwards that I think might get some of the other panel members involved as well, so it's directed to a few of you. So it says, in addition, with regard to challenging contemporary stereotypes of good mothers, perhaps an additional route to challenge that was raised by both Loraine and Salary is perhaps the judicial bench book, which does consider the need for judges to instruct juries on the problem of rape assumptions. Perhaps the wider sexist assumptions which operate here should also be considered by the judicial bench book. So maybe Emma, if you want to comment, and then I think there's space for everyone else to get involved in that conversation.
Yeah, I think that's a really interesting and important point. I suppose there's two aspects to my answer. The first is that because most of these are guilty pleas, it's actually not juries that are the problem. I would say it's the Grand Prosecution Service that, A, for prosecuting, and then B, for what they're going to accept a guilty plea for or not accept a guilty plea for. And there is an element of some of these women, I think if they possibly had barristers and solicitors who were rooting for them a little bit more, might not have ended up in the situation they're in. So I think actually this is potentially other legal professionals and how they're approaching these cases that are to play here. But yeah, certainly that the few that end up with murder trials and an attempt by a barrister to try and convince a jury that the Infanticide Act, this is what the Infanticide Act was implemented for, please let's use it, have effectively been completely redundant. Like juries just don't seem to buy into the Infanticide Act in any way, shape or form, including in one of the cases that I look at in the book. I'm not going to be able to remember the name I gave her off the top of my head now, but in one of those cases, the jury were asked to consider infanticide first, then if they couldn't find infanticide, then to consider diminished responsibility. And infanticide, one of the joys of infanticide, one of the reasons why it was kept by the government when they reformed murder, manslaughter and infanticide back in 2009-2010 was that infanticide is technically easier to apply and easier to use because it's simply the disturbance of the balance of the mind, whereas diminished responsibility requires a recognized medical condition. And yet the jury jumped over infanticide and then found her not guilty of murder, but of diminished responsibility instead. So that, I think, to me suggests even more so that juries just don't really understand or don't get infanticide. They either don't see its relevance or any aspect of that. And the case that was heard just before Christmas, where the woman was convicted of murder and then sentenced to 9 years, I spoke to the barrister before he went into trial. And one of the things I said to him was, I think one of the key things is going to be to try and really explain to the jury what infanticide is and what its purpose is. And he's come back to me and said he tried it, and basically the jury were just, again, having none of it. So I think there's an interesting aspect there. And yes, potentially guidance to the jury might be what's needed. But presumably that means that judges are going to have to buy into the notion of infanticide as well, which at the moment they don't seem to be. Don't know about Sally, Loraine, Michelle, what do you think?
Yeah, either Sally or Loraine, if you want to jump in, and then Michelle, it'd be interesting to see what you thought of, with regard to this from a comparative perspective, maybe, like, do you see this as an issue in the States as well?
I suppose I would just say, yeah, I think it's a good comment. I don't think we would be surprised that people's assumptions are colouring every aspect of the way that these cases get dealt with. So you're starting with the police, moving through the prosecution's service, juries, if juries are involved, judges. We know that, right? Socio-legal scholars, we know that these assumptions are coming in and affecting every layer of that. And I suppose the other thing that's interesting about these cases is that all of those people, all of those different stages, people will be dealing with very, very few of these cases. So again, it's really not surprising, I think, if they're inconsistent. And anything that can be done to improve the way that decisions are made and the way that decisions are scrutinised and the way that people are forced to scrutinise the assumptions they're making at the world at every level of that, I think is clearly very important. I mean, personally, I'm still getting over Lorraine's anecdote about student interviews and whether we take account of the fact that somebody's had their children yet or not, which almost made me choke, actually. So we are all doing that all the time, and we know this. We all have unconscious biases. We deal with that by dragging them out into the open and scrutinising them. So yes, really great suggestion, very, very important that we do that.
And just to add, I mean, I think that Susan Edwin's suggestion of a focus on the judicial bench book is a good one, but what is needed is forensic examination at the very many different levels. Just to make one proposal, an interim proposal in a way, I think public opinion is hugely important here, because politicians will always say, oh, they're just following public opinion. We know that's not so. There is a concept of populist punitiveness, with politicians tapping into what they think is public opinion, but which doesn't necessarily reflect it. When Robert Buckland was Secretary of State, Justice Minister, I had endless correspondence with him trying to argue the case that whereas the public can write in to the Attorney General to say, I think it's the Attorney General, to say that they think that sentences are too lenient, there is no provision for members of the public to write in and say to anyone and say, actually, these sentences are too harsh. And so I still keep hoping that one of the big national charities, Howard League or Prison Reform Trust, will pick this up and fight the legal case. But meanwhile, I think if we know about such cases, we could perhaps generate public opinion against the harsh sentencing that is introduced and try and raise questions that way. but I certainly think that your book, Emma, will stimulate public debate. At least I hope it will be used to stimulate debate in a number of different ways. Perhaps a short article on the book in the Justice of the Peace or something would be helpful.
So I'll jump in, which is a nerve-wracking thing to do because I know so little of how your legal system works. But I'm hearing the question as one of how do we best get to a place where the bulk of these cases can be disposed, or the largest percentage possible of these cases can be disposed of as we think they should be, which is a sort of a much more compassionate probation and counseling and less prison time. And it strikes me that we've learned from, in this country, in my country, we've learned that the gender-related syndromes don't necessarily produce the best outcomes. So battered woman syndrome or rape trauma syndrome, or for a while in this field, one of my colleagues, Dr. Margaret Spinelli, was trying to promote neonaticide syndrome, largely ends up triggering a sort of a ridiculous sidebar conversation about whether this particular defendant qualifies or meets the tests of this particular syndrome, and suddenly you've got experts and you're not talking about her life at all, really. So this actually makes me wonder if it's actually easier to tell a fuller truth under a diminished capacity theory that has no gender attached to it, and it allows the population to just say the thing that you said at the top of your remarks is so obvious, that this is not a normal response. What would cause somebody to respond this way? And to the extent that I'm working on these issues these days, it's largely in conversation with reporters covering cases. And that question, sort of my insistence that they try to situate what must have been going on, that this particular set of events played out in this way, that event seems to change their entire perspective on the case and their entire way of covering it. And just to circle that back to the courtroom, the very first case that I was really involved with was a Chicago case in which a friend of mine was the defense lawyer, teenage girl, same facts that you see in so many of these cases. And rather than deal with a psychiatric expert and come in and explain what was going on and why she and what he brought in an obstetrician who got on the stand, was really sort of a warm, lovely person who said, birth is not a silent process. There were other people in this apartment and she didn't scream. But that's not legally relevant. But the jury acquitted, right? I mean, it was just like what was going on, right? And so there was no talk about gender, no talk about structure. It was just sort of telling the truth about what was going on for the 17-year-old when she was in the bathroom for 27 hours. So I don't know if that's helpful, but it causes me to wonder maybe if there's more space for a thicker truth outside of the act than in.
Yeah, I think, yeah, really great points raised by everyone there. And I know that some of these cases, when you read them and I've put snippets into the book, but the full transcript and the focus of the prosecution on tiny little details of what the defendant did or what she didn't do, and how that somehow, must indicate something. So, and real, I remember one of the defendants, a massive focus on the fact that she tried to have an abortion and she was over the 24-week limit, and so that must demonstrate that she clearly wanted to kill the baby. And you're like, how are you making these conclusions? But these tiny snippets of these women's lives being considered to be the kind of death blow to any form of leniency.
All really important points and a really interesting discussion. There are still some questions coming through in the chat, and lots of congratulations, Emma, people saying that they really loved the book and that they've really enjoyed this discussion, and everybody's comments on your book as well. Just one of those comments, actually, I'll pull out just because it talks about this being a really wonderful discussion and a powerful testament to the importance of the issue. And talking about, so this is Catherine O'Rourke, one of our colleagues, how excited she is to hear about how the work unfolds further. And just from that, I wondered whether you might tell us a tiny bit about the work that you're doing now and how that is building on what's in your book. There are still some other questions, but you mentioned it briefly before, and I think a lot of people might be interested in that. Yeah,
thank you. That's a really helpful prompt. Thanks, Chloe. Yeah, so I've got a small amount of funding from the British Academy, Leverhulme small grants, to interview legal professionals and to try and find out from them what they think about the cases and the law as it currently stands. So the law around the protection of fetuses, the protection of infants. Does the law do what it should do? What do they think about women? And the hope is to interview people who have had experience of these cases, which I've made a list of everybody I'm aware of and I've got a list of over 100 people. So there's actually quite a few of them in England. Like, most of them have only ever done one case, but there are a reasonable number of them across all of these different offences. So the hope would be even just to get a handful of them to see what they say. At the moment, it's only the defence teams who are interested in talking to me. So I think the recruitment aspect is the challenging one, and the one that I'm continuing to face. But fingers crossed, if I can get a couple more people talking to me, that maybe it will advise us as to some of the gaps at the moment. Because I think from the book, I felt like at the end of the book, I knew how the criminal justice system was responding. What I just didn't know was why. And I always think we have this lovely idea that justice is, this blind application of law without anything in the middle. But actually the reality is, and I think what does come out from these cases is that's simply not true, because the prosecution are deciding whether or not to prosecute, and then what do they prosecute for, and then they're deciding whether or not they accept a guilty plea. And your solicitor, if you're one of these women, if you get a really good passionate solicitor, they massively push back and you potentially get a reduced charge instead, although technically charge bargaining is not something that's allowed to happen in this country, but sure. And then the decision around acceptance of guilty pleas, and then judges, what do judges think? And there's one of the questions I've been asked when I've been talking about this research in the past is whether or not the sex of the judge matters. So if it's a man, is he harsher? If it's a woman, is she kind of kinder? And again, it's really difficult to draw conclusions because there's so few cases, but that seems to not really fall along lines. There was one woman judge who told a 16-year-old girl who'd been raped and got pregnant as a consequence of being raped that she flirted with this man, and clearly she didn't want that to happen, but if she hadn't flirted with him, then maybe she wouldn't have killed her baby, which again is just a crazy conclusion to draw from that case in any way, shape or form. And then on the other side of it, a judge telling off the prosecution barrister because he tried to suggest that this woman's domestic abuse wasn't as serious as she was making out. So there really doesn't seem to be any rhyme or reason as to why judges come to the conclusion they come to either, but trying to understand what are some of these gaps and what role do the professionals play in terms of their own understanding of these cases and their own perceptions of how the law should be applied. I think that's the key aspect, and fingers crossed some of them talk to me, because otherwise it's not going to be quite so successful as I'm hoping.
It sounds like really amazing work, and I think it's really just going to further illustrate quite how important this book is, and some of the ways in which the research can really be brought forward as well. Just another question, so this one's from Tony Ward. I'm just wondering whether there is a wider point about the changes between 1922 and now, that 100 years ago, the situation of a crisis pregnancy was understood in a common sense way because the injustices women faced were so glaring. Whereas now, getting or remaining pregnant is often seen as a choice. So unless you're really mentally ill, you're just choosing irresponsibly.
Yeah, I think you've nailed it on the head there, Tony. I think that's a really important part of what the change has been between 1922 and today. And certainly, Tony, you'll know from your work, but the sense all the way through the kind of Victorian period, Edwardian period into the early 20th century of women who killed their newborn children, and in some respects women who had abortions as well, which of course would have been illegal at this point. those women were kind of seen to be partly victims because they were victims of the men who got them pregnant and then refused to marry them. So very narrow situation that women were in, very few circumstances, and that very much impacting juries' decisions to not prosecute. And there are cases. There's a fantastic article by a scholar called Higginbotham who finds cases where there's very clear evidence that the baby's head was bashed in, and yet the jury were like, well, we can't prove live birth, so we're just not going to convict her. We're not going to convict her. We're going to say not guilty. So this sense of it during the Victorian period, there was this real desire to kind of get women off, and juries did everything they could to do that. Whereas that would appear to not be the case today. And I think, as Tony's kind of said in his question there, a big part of this sense of, well, women now have it all, right? We can not get pregnant, we can end pregnancies. If we do get pregnant, we don't want to be pregnant. So these women they've got to just be bad women. So partly they've got to be irresponsible, but they've also got to be just, really quite evil women. And a number of the women are very much portrayed along that evilness, or they've got to be deranged and completely mad. So I think, yeah, Tony, you're absolutely right as part of that aspect.
I wonder whether any of the panelists also have thoughts on this. I know lots of your work sort of touches on these themes in different ways. It'd be interesting if you also had thoughts to share on Tony's question. Loraine.
Yes, only to say, I think that Tony's question fits into the kind of neoliberal way of thinking, as in the assumptions, there are assumptions within the system that if anyone commits a crime, it is a matter of free will, and that individual responsibility rather than collective responsibility is the way to go, and that is hugely problematic. As we know, I think in all sorts of ways, the system punishes abuse, punishes those who've been abused, neglected, so on and so forth. And I think that the focus on maternal filicide in the way that you have focused on it, Emma, I think it's further illustration of a more general problem, but obviously there are particularities relating to women here in this example too.
Yeah, I'd completely agree with that. I think in a couple of cases, the judges make comments like, we shouldn't have got pregnant then, and even like more than that, you shouldn't have been having sex. Well, if you hadn't been having sex, none of this would have happened. So the responsibilization of not just when you became pregnant, but actually if you'd been responsible and never become pregnant, then this really wouldn't have happened. But so yeah, I completely agree with you that it does reflect those very clear responsibilization narratives we see around all criminal justice. And then it just has this very kind of women and sex is bad kind of label then plonked on it as well.
That fits with quite a lot of the work you do, Sally, doesn't it? Those themes, sort of the emphasis on individual responsibility and the need really to remove criminal responses. I wonder whether you have any thoughts as well, just to add to what Emma and Loraine were saying.
I think Emma and Loraine have summed it up very well. I suppose the other thing I've been thinking about a lot in terms of thinking about the biography of these principles and how interpretation of them changes over time is the much broader context that's influencing that. So obviously a massive shift away from religion as a way of ordering society and understanding the world towards more scientific discourses, and I'd really see that rise of liberal individualism as part of that. It's individuals directing their own life rather than having a religiously ordained deterministic path laid out for people. But I think it's so valuable, Emma, to do this work in the way that you have, where you really drill down into the detail and show how those changes happen over time. I think that's very interesting.
And sorry, I feel like I'm picking on all of you, but I'm just interested to hear all of your different perspectives. Michelle, I wonder whether you have any comment, because obviously you're in a different jurisdiction, but I mean, some of these themes look like they might also be applicable in your context too.
Yeah, I'm just paused on that word responsibilization, and how gracefully you said it. It's a very useful frame for me in thinking about, I guess, you know, I guess I'm just laser focused on how to defend these cases, and so the antidote to a responsibilization a la Tony Ward theory is just the truth telling that show all of the constraints. And I mean, my hunch is that it actually is, I mean, it works because it's common sense, right? I mean, if you say, yes, you shouldn't have been having sex, well, then it's so easy to tell the common sense story of why it is that this person was having sex without contraception at a time where maybe they weren't looking to have a baby, right? It's, you know, it's just telling the common sense reality about, I mean, and at least in my country, I mean, you're paying out of pocket for your contraception. It's $1,000 a month, right? You know, it's getting that together to get your IUD in means you're not going to have money for rent or food. So the response to neoliberal responsibilization is truth, right? That's my hunch. I don't know how well it's going to work here as we move into trying people for ending unwanted pregnancies. Yeah.
The thing is, I mean, I completely agree. I think truth is absolutely needed, but the problem with truth is that people have to be willing to hear it and willing to listen. And it's so much easier just to find fault with individual women, because to hear the truth means you have to recognize there's a problem in society that needs to be addressed. And that's, you know, I think as America under Trump, Britain under Johnson, you know, people don't want that, right? That's why they keep voting for these idiots. They want the kind of fairy tale and the idea that it's individual problems, not structural issues.
But like what worked in England historically on these cases was that you could just put the blame onto the guy, right? So you wouldn't ever take blame as a society, but it was like that cad who impregnated her and left, right? And the guys are missing in these cases. Mm-hmm. And so it might be that there are moves available to us that are beyond, or sort of that are safer perhaps than taking on end stage capitalism, right?
Although maybe we should just try and take on end stage capitalism. And it's 6:30, so that's a great note to end on. But maybe before we go, Emma, were there any things that you want to sort of leave us with, like some final thoughts, some final provocations that you really want everyone to go away and mull over?
Well, other than let's end patriarchy and capitalism, probably not, no. Just a massive, massive thank you to Loraine, Michelle and Sally for coming along and saying, you know, having such fantastic contributions. It's been great. And a huge thanks to Jessie and Chloe for all of the work they've done to organise this.
Yeah, so you've sort of stolen the last thing I was going to say, Emma. So thank you so much for taking the time to talk to us all about your book. It was amazing. And actually, thank you as well for letting me read a copy. It was wonderful. And thank you as well to all of the panelists for taking the time to come and talk to us all from your different perspectives. It was amazing. And thank you to Jessie, who did the hard work of the introduction at the beginning.
Lovely. So I think that's about time that we wrap up. There are some final thank you and congratulations comments in the text box, which I'm sure Emma will have a chance to read at a later date. But thanks again, everybody, for coming, and we'll hopefully see you at another seminar soon.